So we'll do our usual run through on Administrivia and then we'll launch in. We have a fair amount to get through today, so we're going to move with some authority. The first thing on Administrivia, of course, is remember that we will be meeting Saturday. Some people were able to meet during office hours after class on Monday, and one thing that came out of that conversation was trying to find other times. I think the quotation from Judge Catt was, "Saturdays suck," and I agree with that. I would love to go and find another time. Here's the question. Does a time on Monday morning, something like, what did we say, Nate, 11 to 1? Or 10 to 12?
10 to 12, so you have a 1 hour break.
10 to 12, so you have a 1 hour break. Is that something that you'd be interested in shifting off, right? Like I can't promise we could get all one or all the other, but as in terms of like not having it always be Saturday, would that be a cool substitute sometimes? Okay, I'm seeing a lot of head nods. If you have a deep-seated profound problem with it and you're uncomfortable saying that right now, please do see me after class, but otherwise we'll move forward with that and try to find a time. Well, sorry, not try to find a time, but one of the future makeup classes that we need to do will probably land in that time slot when it fits everybody. Cool. Any other questions on Administrivia before we get going into where we are in contract formation? Rock on. Then here's where we are in contract formation. I'll tell you what we've been doing. I'll briefly pause to ask for your questions. I'll try to keep my answers short. And then we'll move into 2207 and how the Uniform Commercial Code does all this. So we are still in question 1, that is contract formation. And the difficulty that we've learned is that the demand of the common law for a specific moment when offer, acceptance, and consideration all come together, you get that click. Before the click, there is no contract or no contract law binding the parties, no duty of good faith, we just saw that, right? After the click, there is. It turns out that then raises a further question, which is, can lawyers, by good argumentation, move that moment of the click forward and back in time in order to make different kinds of legal arguments? And that's been the skill we've largely been looking at. Now, we looked at it in the company buying context with letters of intent, but then we also looked at it most recently in the renegotiation context or in the good faith context to just reestablish that our moment of click really determines, as of the click, there's contractual obligations, and one of those contractual obligations, in fact, is to execute and perform the contract in good faith. So that's what we've been doing. Now we're going to look at the moment of the click in terms of commercial law. That is, one economy later. This class deals with 4 economies, 2.5 of which are still in your book. The reason why the second half of the third economy and the full amount of the fourth economy are not in your book will be made clear today. Those cases don't exist because the case law we are looking at today has prevented that case law from coming into existence. You can't get cases when you see the results of the contracts that we will look at today. So that's why that happened. The economies we've been looking at are kind of the cozy core mom and pop services economy. That's sort of up through the post-war era. We then get the industrial, commercial law economy of trucks and factories. We're going to move now just into the intellectual property economy of software licensing and internet-enabled or electronically enabled devices. It's no accident that the fight that we see in Gateway is actually about a computer, even though there's no reason that it would be purely about a computer. It doesn't change the law at all. But then that law becomes the law of the data economy, which is where we are now, where the most important thing that's being bought and sold is data about us, used to extract all we can pay through targeted behavioral advertising. That's the economy that we're coming to. And we'll talk about why in, I think, the 6 years since this book came out, 5 years since this book came out, I think there's been like 1 case against Apple, and we'll talk about why there are just no cases in the case books anymore. All right, cool. That's where we're going. That's where we've been. That's where we're going. Any questions you have about anything we've done in the class up to date? Yeah.
What exactly do we need to know about culpa and contrahendo?
Okay. What do you need to know about culpa and contrahendo? You need to know that what it means. It is Latin for fault during the contracting process, that is, during negotiation. What it means in common law, we translated it as a duty of good faith while you're negotiating. And what the common law says is there is none. That's the main thing you need to know. You need to know that it exists and that it does not exist here. The reason that you need to know that it exists and it does not exist here is then you begin to figure out, hey, if that's something your client wants, that is, you're going to be engaged in protracted and expensive negotiations and you really would like the other side not to hire away your key staff or plaster your financial numbers all over the financial web or steal your intellectual property or something else, right? Do bad faith stuff. If you want to stop people from doing bad faith stuff, we explored a couple of ways you could make those arguments. One way you make those arguments, and probably the best way, the only airtight way I'm aware of, is to really Butler versus Bologna this. That is, actually come up with an agreement, not an agreement to agree, which doesn't exist, but an agreement to not be jerks during the negotiating process and have these things be terms of the agreement not to be jerks. You're not agreeing to come to a final resolution, but there is a mutual exchange of promises. Something for something, that is offer, that is acceptance, that is consideration. It is a bargain for exchange when we say we each will not hire each other's employees away that we find are key employees as a result of the disclosures made during this process. We agree to keep each other's information confidential while we negotiate. That's the only way really out of this from the front end. The problem there is, for those of you who are in the room who are litigators, go learn to talk to your deal makers. I know we're like kept apart from each other, and it's almost like the plague separates us, but go talk to your deal makers because that is a solution only your deal makers can make. You have to solve that one at the outset. We're left with the problem of what happens when the deal makers didn't do that, and then litigators have to come in and clean up the mess. And then we saw a series of arguments where we tried to work out ways to say certain things that jerks do when there's no contract yet might be approaches you could bring. One of them is you might try reliance. Another is you might try restitution, right? We don't have a contract because you've convinced the court to push that moment back in time, so we didn't have a contract. But the other thing you can do is not just try reliance, not just try restitution, but grab that lever of contract formation and yank that sucker to the point in time that you need so that then you can say, oh, there was a duty of good faith and obligation because we'd already entered into the contract as of this point, right? Duty of good faith starts when the contract starts, so cool, make the argument, yank that lever that the contract has already started and therefore you owe me a duty of good faith. All right. We're going to continue to play games with that lever. Other questions? Yeah, Larry. Yeah. Yeah. Repudiation of a contract is something that we will begin to see later on, mostly when we get to remedies. For now, what you need to know is often we use the language of contract repudiation to talk about a breach of contract that hasn't been performed yet. Here's another piece of legal terminology that I will use often and almost without thinking, so it's probably worth noting it. There is such a thing as an executory contract. An executory contract, here's how you can think about it. An executed contract is one where we fully performed. We're done now, right? An executory contract is one that has not been performed yet. And the basic principle of contract law is that there is a contract not when you perform, but there's a contract when there is a promise for a promise you will perform for a promise you will perform. At that point, you have what is called an executory contract. And this will be very important for us to understand 2207 when we get to it. But the idea then of a repudiation is, let's say you have an executory contract. That is, a contract where we have a promise for a promise, but neither party has performed yet. Let's try it. This truck I keep trying to offload in response for, $1,700. You're into it, right? Like I know you are. I will offload this truck. Right, so let's say, do you see that I have, in a hypothetical scenario, since you've refused my kind offer, in a hypothetical scenario, right, I have not delivered the truck to you yet, and you have not delivered the $1,700 to me yet. And if I were then to say, but I repudiate this contract because I want to sell it to Fletcher instead, so I've now repudiated the contract, what that means is you get to sue for breach. because we still had time to perform on the contract, right? So it sort of forces the question of breach. That's what repudiation is. Repudiation says, here's a deal that we made, but we haven't done yet, but one party is saying, nope, not going to do it. And that lets the other party sue. Okay. Any further questions before we get into 2207 and Gardner-Zemke? Yeah, Scott.
In its like simplest form, is the black letter law of Empro just that, like our kind of marriage example, where an agreement to be married means you're not married?
That is, Judge Easterbrook thinks for the way that companies act when they are selling themselves to each other, that you don't have a done deal until you've got a done deal, and all these memoranda of intent are just provisional. He's dumping it on the parties to make it clear when they've done a deal and saying, until that's clear, you don't have one. Unfortunately, he's also dealing with a whole bunch of counter arguments that say, no, it looks really clear to us that we had a deal here. See Arnold Palmer, where they fist bumped and had binders on TV, right? That really looked like we had a deal, we just hadn't written it up yet. So Empro stands for 1/2 of a lever pull, right? It doesn't stand for like this wins. That's why we went through each of Easterbrook's arguments and realized none of them is right. Board approval clauses do not let everybody walk, right? Subject to language does not mean that the document that it says subject to cannot evidence the terms of a fully made agreement. That's also true, right? And the whole idea saying that it's not possible for companies to come to an agreement before they have a signed, sealed, delivered memorandum flatly contradicts Restatement 27. He's wrong once, wrong twice, wrong a third time, except if I'm paid to be representing his client, in which case he's right all day. All right? Cool. Any questions, any further questions on that? Okay. So let's turn to 2207. If you've got your supplement with you, you should turn to Uniform Commercial Code Article 2207. You will notice that Article 2, if you have more than one article in your supplement, for those of you who've gotten like full supplements from upper level courses or whatever, we're not talking about almost any other element other than Article 2. Article 2 is sale of mobile goods. When I say, is this under the UCC or is this under the common law? When I say, is this under the UCC, almost always I'm saying, is this under Article 2 of the UCC? There are other articles. Article 8 governs equities, stocks, and bonds. Article 9 governs secured transactions. That is your car loan and the documentation necessary that they take out your car as collateral and come kick in the door and seize it if you don't pay your bills. That's Article 9. Article 12, for anyone who's interested in cryptocurrency, come talk to me. It's sweeping the country right now, and it's changing the rules about how people are buying and selling crypto. But we're not talking about those in this class. We are talking about Article 2 of the Uniform Commercial Code. And 2207 is one of a number of rules that you will need to know from the code. Off the top of my head for this class, the ones that you need to know the most, and we've already even addressed some, are 2201, which is the statute of frauds, that is the need for a writing. We haven't really talked about that yet because we're not in our formalization question yet. We're still in our formation question, and we're going to be asking questions about formation under the Uniform Commercial Code today. That's what we're going to do, is say, how's formation of a contract different under the UCC than it is under the common law? Now, the other one you need to know at the end of this class is 2202. Should you know it yet? No, we haven't talked about it yet. That also is a formalization doctrine. But you should take a glance at 2205 and 2206 because they will help set the stage for 2207, which is the one that you really do need to know and which I'm about to put up on the screen. And the reason I ask you to bring out your supplements is that you should just draw arrows where I tell you to draw arrows, and then you will not make mistakes with 2207, which is otherwise a very, very difficult provision to parse. All right, so that's what I'm going to do. Before we even get to Gardner-Zemke, for those of you that I ask to do Gardner-Zemke, pay attention. I'm doing a lot of where the law ends up in this brief flowchart / workflow setup for 2207. But I'm going to just run through 2207 and what it does and why, and then we'll get into Gardner-Zemke, in which you'll see the court stumbling around. Now, what I'm about to tell you is an amalgamation of doctrine from 50 different states. And as you can see from Gardner-Zemke, and we'll talk about it when the time comes there, There are about as many opinions on this as there are judges. It's a mess right now. It was not a successful provision. But we're left to, like I think the quote in your book was something like it was a tank that was, designed for swamps and is being fought in the desert. Yeah, it's just a bad one. In fact, it's so bad that I will give you relief. What I'm about to tell you is the way it works. It is the opposite of how it is written. If you read it, and this is the whole end point of Gardner-Zemke. Here is the holding of Gardner-Zemke that you need to know, which is 2207 was so badly written, the court had to radically rewrite it to say almost the exact opposite of what it actually says. That's really what Gardner-Zemke stands for. So I'm going to tell you how it really works now using the law. I am not going to tell you right now how it really reads. We will get into how it really reads in Gardner-Zemke, but we should notice that how it really reads is nowhere the law. And how it really works is the law almost everywhere. The law of Gardner-Zemke is the law almost everywhere. All right, so here's what it does. Any questions on that before we pile in? And I'm going to just put 2207 up on the screens here. I know technology use in this class. Who ordered that for lunch? All right, here's the major drafting. First of all, let's get to what 2207 was really trying to do. All right? The focus of it, of what 2207 was trying to do, I need you to understand by the end of what we're about to say why they did what they did, and then ask yourself, did they succeed? That's what I need you to take away from here. So here's what they did. They said a definite and seasonable expression of acceptance. Definite means not vague. Seasonable on the bar means you don't just get to wait to respond for months. There needs to be a reasonable period of time where you respond. A definite and seasonable expression of acceptance. What's an acceptance? A sign, action, letter, something signifying that you accept. Which was sent within a reasonable time, operates as an acceptance, and then if you're following along and you have highlighters, highlight the following text. Even though it states terms additional to or different from those offered or agreed upon. What the hell does that mean? What did they just do? Operates as an acceptance, even though it states terms additional or different to those agreed upon. Yeah. They got rid of the mirror image rule. Superb. Tell me how.
The mirror image rule states that both the offer and acceptance have to mirror each other and have the same terms. But now that they're saying that it can still count as an acceptance even if there are
additional or different terms. That is, a yes and a yes and do not form a contract at common law. You with me so far? A yes and a yes and do form a contract under the Uniform Commercial Code. We have to watch out for that. So that's thing one. That's what they were trying to do. That is, 22071 is a rule of contract formation. It is saying, when is a contract formed? And the answer is when what the common law would call a rejection and counteroffer happens. The UCC says, nah, y'all have a contract. With me so far? Now, there is one piece that turns out to be technically important. It's not philosophically important, but it is very technically important so that you can focus on the philosophy and the theory of the law and not worry about getting it right. And so in a different color, if you happen to have it, or circle it if you were doing all the things, I need you to take a look at this language. So use a different color. Unless acceptance is expressly made conditional on assent to the additional or different terms. Anybody want to take a crack at what that means? Yeah, Gene.
If the yes and says yes and you also have to accept this as the final offer, there is no ifs, ands, or buts on our end.
That's correct. Or what? What's the or? You have to assent, you have to accept every change we've made, or?
Or there is no deal.
Or there is no deal, or?
I was going to say
Yeah, there's no deal. But more importantly, I need to see why you have the power to say that. Because this is called a my way or the highway clause. This is called a my way or the highway clause. Where do they get off thinking they get to add a my way or the highway clause?
We won't deliver on our half of the contract.
Yeah. We will not accept. This acceptance does not operate as an acceptance unless you agree to the terms that we have put into the contract. Do you see that? Now, can you think about why they might have done that? Why would they say, you can put in a line saying, we've put in something different, and unless you agree to it, there is no contract? Why would they do that? Leland.
Because then if you proceed as normal, that's you agreeing even if you don't actually acknowledge it.
Because performance, and we'll see this in 2206, this is the trick, this is the thing. Of these actions you can take to conclude a contract, remember the action we were looking at last time to conclude a contract? We were pretty pissed about it. Submitting a bid was considered to be an action that had contractual significance. Here, the action that has significance in the commercial law context is shipping the thing. All right? Is shipping the thing. You have agreed by shipping it. So we have this problem then where we get so what happens then if you get a my way or the highway clause? And there's two versions of this that often appear on the bar exam. The one is that A says to B, I would like to buy a computer. B responds to A, yes, and the computer must have this amazing warranty on it. If you do not assent to these terms, this does not operate as an acceptance. A ships. What's that actually do in terms of contract formation? Yeah.
It accepts B's terms.
It might be held to accept B's terms, right? It really might be held to accept B's terms if we treat this as a counteroffer. You with me so far? That is, we've brought back the last shot rule. We were trying to get rid of the last shot rule. Tell me why abolishing the mirror image rule also abolishes the last shot rule. Remember how the last shot rule works, right? Like, let's play tennis. So I say, I give you the power to accept, and you say yes and you pong it back to me, right? Can you see that if I say yes at that point, the contract is the yes and? Right? But if I say yes and back to you, if you say yes, the contract is yes and. The last shot wins, right? Back and forth. How does abolishing the mirror image rule affect the last shot rule? And if it's an unfair question, like, feel free to call in co-counsel. Sure, yeah, go ahead.
Is it just because there is no mutual assent?
Well, or maybe there is a different kind of mutual assent. Go ahead.
The performance is the acceptance.
The performance might be considered acceptance, but if it is, we've just re-enshrined the last shot rule again, right? That is, in fact, often what happens in these rejection and counteroffer, rejection and counteroffer, rejection and counteroffer cases. And that's why this statute, you can't read it exactly as written, because it's going to create profound confusion where the last shot rule starts trying to crop up again. And then worse than that, which is, by the way, Gardner-Zemke, and then worse than that, if you actually read the way the statute's written, it gets replaced with an even stupider rule, which we'll call the first shot rule, which is the law nowhere in the Uniform Commercial Code. The first shot rule says that whatever the offeror sends first wins. Right? We'll get to how that can work. For now, here's what I need you to do. Now that you've got this highlighted, draw an arrow from this section to this section. You with me? This is not in your book. This has not been taught to you. This is the way that I teach it in upper level sales. And it's much, much easier. What this means is, let's imagine that both parties say, this offer only acts as an offer if you assent to every term in here and don't change a thing. And then the response says, this acceptance operates as an acceptance. If and only if you agree to everything contained herein. And of course, the words of the offer and the words of the acceptance are different. Here's one of the first places that we get a thing of sanity. First of all, what's the legal effect of exchanging those two forms under 2207(1), where we started? What's the effect of exchanging those two forms? Two opposing my way or the highway pieces of paper. Yeah.
You only accept the terms that are the same in both?
That turns out to be where we are going. That is absolutely correct. That is where we are going. What's the effect of the exchange of documents?
That your contract is formed even if they say different terms.
Contract is formed even if they say different terms. By the way, let's hold that thought because that happens under 2. What happens under 3?
So under 3, there's no contract.
There is no contract. Why is there no contract, Scott?
Because they both made their acceptance conditional on the other party's acceptance.
They made their assent to the contract. By the way, can you hear it where we're starting to talk less and less about offeror and acceptor and just being like both parties withheld their assent to the contract, right? And this is very much a both parties rule, not A then B rule. This is supposed to be a both parties rule. And the both parties withheld their assent to the formation of a contract unless the terms were exactly what they dictated. Well, what happens when both parties kind of throw that kind of tantrum? What does that mean for contract formation? Under this, it's formed anyway. When? So, but to be clear, the exchange of writings does not form a contract if one or both sides have a hell or high water clause. I want to make sure you understand that. When you detect on the bar exam or on my exam a hell or high water clause, what that means is your life is about to get easy, not hard. Because when one or both parties has a hell or high water clause, the writings of the parties did not form a contract. Instead, what did form a contract? Their conduct. What they did. Tell me the kinds of things that courts are going to be like, yeah, you did the thing.
I mean, like the case of ordering over the telephone, just paying for a computer, they didn't have to like anything out, but like the natural components are there. Hey, I want a computer, here's the money.
Yep.
And then he accepts the package, he uses it.
Love it. That is, we just go down that list of about 3 things under the code, right? That is, you need a number of computers, cool, 1 computer. You need an object of the transaction, a computer, and it costs money dollars. And then you send that, and then they respond back with their hell or high water clause. At that moment, you've said, I would like a computer for money dollars. They come back with a contract that has a completely different set of terms in it. Do you have a contract? No, you don't have a contract because there was a hell or high water clause and the terms that the parties sent to each other didn't agree. Now, if you think all of this is running straight into Easterbrook and you're beginning to ask yourself, what the hell was he smoking when he wrote Gateway? I know. I'm with you. I'm setting him up. All right. Go ahead.
Just to clarify, hell or high water clause is like a conditional acceptance clause?
It is a conditional acceptance clause. There are 2 kinds of them. They come in a bunch of different flavors when we start getting really hardcore and getting down into the states. Gardner-Zemke shows you a weak version and a strong version. In some jurisdictions, the weak version works, right? Saying, it's got to be my way. All you have to do is throw the tantrum. It's got to be my way or my condition or my assent or I withhold my assent. It's got to be my way or I withhold my assent. That's the weak version. Get the strong version. The strong version is, it's got to be my way or I withhold assent. You have to tell me you like it. You have to actively assent to my changed terms. That's actually where the court in Gardner-Zemke comes down. But either way, if you see something that looks like a my way or the highway clause, essentially saying, I'm withholding my assent to this contract unless you agree with everything I've written, there's a very real chance that that triggers a my way or the highway clause. And what you need to do is just drop down to 22073. Here's the trick on the bar exam. If the contract has not been performed yet, there is no contract. You with me? That's where they'll fool you. You will learn the knockout rule. You will work very hard. You will study very hard, and they will do this crap to you on the bar exam. I'm telling you right now the move that they will do. because you will, by the end of this class, understand the knockout rule, which is what we're talking about, every day and all day on Tuesdays. But because you understand it, they will hit you with this sneaky thing, which is, remember, until you get the conduct that forms the contract, you don't actually have a deal on the writings. You have nothing until they've actually executed. And that's the nice bit, because if you have an executory contract, you're going to need 22072 to have an executory contract, to enforce that contract when nobody's done anything yet. They've just swapped writings. That'll be the test that they'll do. But fine, let's now get onto the rule. This is what you will learn, and you'll all get it right because it's so easy. The contract under 22073, contract by conduct, what are its terms? The terms on which?
I said it's the terms that which were agreed upon in the writing.
Yeah, the terms on which the writings of the parties agreed. And we just leave everything else out, and we fill it in from the code if we have a gap, and we fill it in from industry custom and practice if we have a gap. But otherwise, we just knock everything out. And I would prefer the term leave everything out, because I tested on a bunch of Hornbooks and AI this morning, and they're actually quite wrong on this. So I'm going to call 22073 the left out rule, because everything that's not the same in both agreements drops out. And Chris, while I'm setting you up, that telephone order on the phone, right? That is, let's do a straight left out analysis. So I say, I would like one computer, please. And you say,
Sure.
that'll be
$1,000.
money dollars. And then I'll say, great, I agree, right? And then you send me but it turns out your acknowledgement form says there's a my way or the highway clause in it. Hell, for good measure, I've stuck a my way or the highway clause into my communications with you, right? So now, as of the point that I hang up the phone, do we have a deal?
No,
No, we don't have a deal. Technically speaking, we don't, because
I haven't sent you the computer and you haven't paid me.
because I haven't paid you and you haven't sent the computer. Fine, then you do send the computer and I do pay you, right? But, and also at that time, we have these two different writings. And the question is, what terms of those writings do we enforce?
Like I said before, like the very basic ones like price and quantity, stuff like that. And then obviously anything that you two did agree on in boilerplate. And then if you don't want to throw 2207 out the window like
Easterbrook did.
then it's going to default to already made provisions, like warranties and stuff like that. If you two don't agree on something, it's going to go to default and stuff.
Okay, so this is going to get down into the real fight that then we're setting up in Gardner-Zemke, which is what's the actual, when I say contract 1 contains term 1, and they're super mad about it, and contract 2 contains term 2, and they're super mad about that, the term 1 and term 2 that's almost always being fought about is basic warranties. One side's going to say, if you screw up, it's on you. If it breaks, it's on you. And the other side's going to say, no, no, if it breaks, it's on you. And then guess what? They ship it, they pay for it, and shockingly enough to everybody, it breaks. And that's when you get the fight. All right? So that's the easy part. Here it is. You say, is there a my way or the highway clause? If there are, can the writings form a contract? The writings cannot form a contract. That means you have to wait for conduct. If you get conduct, the terms of the contract are the terms on which the writings of the parties agree. Real straightforward. 22072 is a nightmare. I just need you to see it before I tell you how it actually works, because they screwed up the drafting. And this is one place where they screwed up the drafting so profoundly that almost every court in the country has just said, no, I am not doing that. I may do something different from what we talk about today, but I am probably I think I've seen a case. I am probably not ever going to do what it actually says. And to do that, we need to understand just a little bit about how it works. So, to begin, I'm going to give you the actual law and rule. All right? Then we will go into what it actually says and why you can't let it do that. Here is the law and rule. If I say I would like a computer, please. You say, that will be money dollars. I say, great, and by the way, I retain all warranties. And you say, great, that's fine. By the way, I disclaim all warranties. And then you ship the computer and I pay for it, right? What was missing from that narrative?
Agreement on the warranties?
Agreement on the warranties? What was missing from that narrative?
Condition of, like, the condition of acceptance.
The hell or high water clause was missing from that narrative. There is no hell or high water clause, which means we don't do that arrow you just drew, which goes down to 22073, and instead we go down to 22072. Now, I'm going to say a single sentence. I'll probably need to repeat it a number of times because I'm going to give you the whole black letter law of this area at once. This is how it actually works. No, if you read it, this is not how it reads. Here it is. If you don't have a hell or high water clause, then between merchants, additional, comma, immaterial changes may become part of the contract unless directly objected to. I'll say it as many more times, as many times as y'all need. Between merchants, additional, immaterial changes will become part of the contract unless specifically objected to. Let's try. There is an additional immaterial term that might become part of our contract. So let's say I would like to buy a computer and you say, yes, that will be money dollars. And I say, fantastic, great. And like we hang up. What obvious term have we left out? That's not a big deal. We've talked about terms that are a big deal, but like something that's just like not a big deal.
Color of the computer?
Well, I mean, if you asked my spouse when I got my iMac, right, she like got the bright blue one and I was like, what? No, I wanted the titanium silver. Serial number, yeah? Method of delivery. The time and method of delivery is overwhelmingly one of these. And so let's imagine then that we are both merchants of computers. That is, I am not just a citizen, I am a merchant of computers. Then in the following case, here's what would happen if 2207 is actually going to work. I say I would like to buy a computer for my shop, because I'm a merchant now, right? I'm not just buying it on my own behalf. I am buying a computer for my shop. You say that will be money dollars. I say, great, ship it. You come along, you fire back and say, fantastic, delivery will be by Thursday at 8 a.m. I don't respond to that. I then sue you for breach of contract when you don't deliver earlier than that. And your response is, no, that became part of our contract. I'll say it a third time. Between merchants, additional, immaterial terms may become part of the party's contract on the writings unless otherwise objected to. That's how it works. Now, there's one corollary to how it works that courts have begun to twist the words. And I will tell you how it really works before I show you why they had to really twist the words. They were given no choice. The wording is that bad. So here's what they did. They said, what if, though, it's not a fight about the shipping, which is an additional immaterial term? What, in fact, if I say, I would like to buy a computer, please. You say, yes, that will be money dollars. I say, great, ship it. And the email that I say, great, ship it, also has an attachment to it that says, all warranties apply. And you say, absolutely, we're shipping it now. And you fire back an email that says, by the way, this is sold as is, there are no warranties. Given the sentence I just gave you, what are we going to do with that difference? We did before an additional immaterial term. But what are we going to make of this difference? Given the sentence I gave you, not the language of the statute. Given the sentence I gave you, what do we do?
I was gonna say materially like alters it.
Yeah, so courts have begun to say things like it materially alters it, so it simply doesn't come in. Okay, cool. Give me another reason why it might not come in. And courts have picked, if you ask me what the answer is, I will tell you there is such wind under the court's wings because of the drafting problem that I will show you. There's such wind under their wings, they're like, yeah, oh yeah, that's a good reason to oh yeah, no, that's a great reason to rewrite. Oh, like, okay, absolutely, I will take this reason to rewrite it. Because they can't apply it as written, it's mental. I'll show you how it's written in a second, but I need you to see how it actually works before I poison your mind with how it was written. Right? There it is, because it's different, but that begins to cause the problem if it's different, if what's different. If what's different. Look down at the statute. If what is different. Let me get the language up in front of everybody here. This is where it becomes a problem. What is different from what?
And saying that the additional terms have to be different?
The acceptance additional terms have to be different from the offeror, from the offeror's offer. Can you see how that creates a huge problem? We are now privileging the offeror again. We thought we were done with that shit. We thought we abolished the mirror image rule and with it the last shot rule. Can you see what the language did that made it worse? Is it said, if I give you an offer and you have an acceptance that's different from my offer, what happens? If I give you an offer and you have an acceptance that's different from my offer, what happens as of that point? We're going to get to what the terms do in a second, and you're absolutely correct. I'm going to come right back to you. But I need to know what happens as a matter of contract formation. I say, I would like to buy the computer. You say, yes, that'll be money dollars. What happens if there's no my way or the highway clause? Yep. You have a contract. So I need you to understand the threat here. The threat one is, although the parties said different things, they now do have a contract. The click just happened. They are bound by a world of laws that just applies to them that wasn't there a second ago. The second thing then is, what are the terms of that pocket universe that we just created? And what's the problem as it's written with an acceptor saying thumbs down where the offer says thumbs up? Who wins if we apply this as it's written? Offer says thumbs up, acceptor says yes, thumbs down. The offeror wins. Great, give me clean textual analysis. Why does that show that the offeror wins? Yeah, the and is a proposal for addition, which means it hasn't been made part of the contract yet. The and in the acceptance. Can you see that we're calling it an and in the acceptance? We might also equally call it an and not in the offer, right? We're privileging the offeror again. Does everybody see that? The words of the statute create a disastrous state of affairs. If you follow the words of the statute, it abolishes the last shot rule, in which the last person to say yes and wins, and creates the first shot rule, which is the person who says yes and loses. And the contract is on the terms that the offeror gave, not on the terms that the offeree gave. So we've replaced the last shot rule with the first shot rule. And when we look at Gardner-Zemke, that's the only thing you need to know about the case. The court's like, look, I got to find some other way of doing this because this is stupid. We're not going to replace the last shot rule with the first shot rule. We're not going to just say the person who volleys back last always wins. That's a dumb rule. Cool, then the person who sends it first always wins. They're the one that wins. That's nonsense. Because it's nonsense, here's what courts did. They applied the knockout rule to Article 2207(2). If I say no, you say yes, we are deemed to have automatically objected to each other's terms, which knocks them out, and we replace them with gap fillers. It looks a lot like 2207(3), but notice that the tension comes from something different. In 2207(3), it comes from the fact that they're just not in both contracts. If it's not in both contracts, just no. In 2207(2), though, it comes from I say potato, you say potato, yeah, we're going to call that particular one off. Right? That's an interpretation. Is that the text of the statute? It absolutely is not. The text of the statute, if you apply it, achieves the exact opposite of what they were trying to do when they wrote it. And so no court, one, like 30 years ago, but no court applies the first shot rule. I just need you to see the first shot rule to understand why in Gardner-Zemke, the court's just like, yeah, and now we will be making some law up because we can't apply the statute. It's too dumb. Okay? Any questions on how we do this? Flowchart for your work. Look for a highway, my way or the highway clause. If you see one, go to 22073, workflow, subpart A is, check for conduct. If none, no contract. If conduct, then contract where the parties agree. Workflow part 2, if there is no my way or the highway clause, go down to 22072, recognize that you are not going to apply it as written. Instead, you will say, additional, between merchants, additional immaterial terms become part of the contract, but different terms are knocked out and replaced with gap fillers. Okay. Got a bunch of hands. Riley, yep.
Would you do the flowchart again, but just the yes side? I got all the
Sure. So we'll do it. Okay. If there is a my way or the highway clause, we're now doing the no side?
no yes side.
Or we're doing yes side. You got the no side. Okay. If there is a my way or the highway clause, yes. Check for yes, there is no contract yet. Check for conduct. If the goods have been shipped and paid for, great. Go down to 22073, form the contract of what the parties agreed upon and gap fillers for anything they didn't. That is what I will call the left out rule, because I think there's a need for significant clarity here. Even I checked AI before I came down here. It is a disaster on this stuff. It doesn't know what it's talking about at all. Go ahead.
Just for fun, can we hear the no side again?
You got it. If there is a my way or the highway clause and there is a no, we go to 22072 and we check the first thing. Are both parties merchants? Because if both parties aren't merchants, we don't go any further down this line. If both parties are merchants, we say, is this an additional or a different term? If it's a different term, it's knocked out. If it's an additional term, we go on to step 3. If it is an additional term, is it material or immaterial? Warranties are material. Shipping is immaterial. If it is an additional immaterial term between merchants, it becomes part of the contract despite not appearing in both writings. But if it is a different term, they knock each other out, you fill the gaps. If it's an additional material term, it just simply becomes a proposal for addition that doesn't become part of the contract and doesn't stop the contract from forming. Okay? Yeah.
What happens if they're not both merchants?
If they're not both merchants? Yeah. I'm so glad you asked. I'm going to give you the answer, but then I'm going to have done brain damage to everyone. Right? Here's the answer. Of course, if they're not both merchants, then there is no contract formed under 22072, and even the additional immaterial term does not become part of the contract. No term that is not in both parties' writings becomes part of the contract. That's done for a matter of consumer protection. You can see why. Because if you didn't have that protection, then a merchant might add terms to a contract that the consumer's never seen. Yeah, I know. To a contract that the consumer's never seen, and then ram those contractual terms down on the consumer and force them to follow those contractual terms, Judge Easterbrook. That would be the result, which is clearly a violation of this law, Judge Easterbrook. And that's exactly what Judge Easterbrook holds in Hill versus Gateway, right? That's the fundamental mistake he makes. And that was the core of the Hill's argument. The core of the Hill's argument was, what are you talking about? You can't impose additional, even immaterial terms on us. We're not merchants. All right. We've done this top to bottom. Yeah.
What exactly is constituted as a merchant? Like if I buy 2 extra laptops.
Love it.
And sell it.
Yep. So here's the answer. The definition is in the Uniform Commercial Code. You can Google it, go look for the definition of a merchant. I believe it's 2104. The definition of a merchant is either a person who has specialized knowledge of an industry or specialized knowledge about commercial law. You are not a merchant if you don't know those things, if you're just acting as an ordinary civilian. And you're also not a merchant if you even are a merchant, but you're like, I'm a merchant. I'm selling computers all day long. I go to a store, I buy a fishing rod. Yeah, I'm not a merchant for purposes of that transaction. I am a merchant, but I am not acting in my mercantile capacity, are the two tests that they put on the bar. In my upper level class, although I don't think I've done enough damage to you yet, in my upper level class, I say a merchant, at least as a matter of commercial law, is a person that knows the definition of merchant under the Uniform Commercial Code. Because you have specialized knowledge of commercial law. I am in fact a merchant, because if you go look at the comments, they'll call it the law merchant. I am in fact a merchant. I am not, there's another kind of merchant that you run into on the bar called a merchant in goods of that kind. I'm not a merchant in goods of that kind. If I sell you this pen, I don't regularly sell pens. But I do have specialized knowledge of commercial law. But remember that when I buy a pen, if I buy it for my law firm, I'm acting as a merchant. If I buy it, however, or for my consulting business, I'm acting as a merchant. If I buy, a fishing rod for my own private use, I'm a merchant, but I'm not acting in my mercantile capacity right now. And so I don't count as a merchant. Great, great, great question. All right, yeah, Nate.
So if additional term is material, then that is a...
As written, an additional material term should not become part of the contract.
And then so we look at 2207 to fill in, like with other elements of UCC, or that's only...
We always look at, we will fill all gaps with the UCC, uncontroversially, and where the UCC is silent, more controversially, with industry custom and practice. Yeah.
Can you explain what's so bad about the language again?
You bet. You bet. You have to start with what they were trying to do. What were they trying to do? Abolish the mirror image rule. Why were they trying to abolish the mirror image rule? What's so bad about the mirror image rule? Yeah.
It's impossible with the modern standard form boilerplate contract.
Because in modern standard boilerplate contracts, you never reach the mirror image rule because we keep getting stuck where parties are like, yes, and 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 no one says yes. And then they ship the freaking computer and they pay for it and it goes on for years. And then after all that time, they're like, yeah, but there was no contract? What, please? That's what they're trying to do. They're trying to abolish the sense that one party has it better than the other party. It's really just two parties coming together in a commercial transaction. What they agree on is the contract. What they didn't agree on isn't. It's a real simple framework, right? But the problem is that this language does not achieve the goals that it intended. What this language says is, we do form a contract when offer and acceptance are different. By the way, they should never have used offer and acceptance if they meant to abolish the terms. That was stupid. Right? Because then they started making drafting mistakes. Drafting mistake number one was leaving unless offer or acceptance is expressly made conditional. Nope, it's acceptance. They're tying the sentence that follows to the acceptance. And what you notice here is the way it's written, the acceptance, all of these different terms are just proposals for addition that do not become part of the contract. They almost never become part of the contract. And if you read that, what that means is the acceptance does form a contract with the offer, but the different terms, the additional terms simply don't come in. Different terms don't come in at all. Your contract is purely on the offeror's standard. You see it? By the way, having convinced you that that is a very, very bad rule, that is overwhelmingly the rule in the United States. I will now call it something that you will never find in a Hornbook. That is called the only shot rule, which we will get to in Hill, where there aren't really this back and forth at all. It's just one shot. The shot that is fired by the computer beats anything that the human can say. And that's a weird result given what we just went through. All right. Any further questions on 2207, the flow chart, how to work it, what it means? Yep.
Is it true that anytime there's conflicting terms, you're just going to knock it out and replace it with something in the UCC?
No, because I'm giving you a mediocritized pulled together synthesis of a bunch of different decisions that go in a bunch of different directions. The real answer is in your jurisdiction, read the case law on 22072. They're all over the map. For this class, the answer is yes. Any different terms are considered automatic objection to each other and therefore knock each other out. But where one says something and the other one is silent, that makes it an additional term, not a different term.
If that's material, is it still?
If it's material, it still should be left out. Yep, if it's material, it still should be left out. Although then, courts start manipulating that. To jump ahead a little bit, want to guess what the courts will deem the addition of an arbitration agreement, which says the parties can actually not go to court anymore? Is that a material or an immaterial change?
Well, it seems material to me, but I know the court says that.
Right? Seems pretty frickin' material to me. But the court's like, yeah, we're going to just hand wave this. Why? Because Judge Easterbrook has been hand waving from the beginning. Like he's just been windmilling over here, and the courts are like, we'll hide behind him. All right, cool. Go ahead. What's more? Fire away.
So there's no highway and highway clause?
Yep.
You just jump straight to that additional or different term branch?
Yep. And you see, can I get a contract on the writings? Cool. All right, let's move into Gardner-Zemke. We're going to move through these pretty quickly. Gardner-Zemke is dense. Fortunately, we've just done all of the black letter law I need you to know from Gardner-Zemke. So we're going to just talk about how that is a different case than the national standard. Do you understand? The national standard is what I just taught you. That is how it's going to work out most of the time. Gardner-Zemke is a very specific case. It's going to do a few things that are different, but they're not really all that big a deal. And with that in mind, let's see. Chris, would you mind going with Gardner-Zemke and setting it up for me, please?
Yeah, so this is a Battle of the Forms case.
Yep.
in New Mexico.
Why do you know it's a Battle of the Forms case?
Because the court said it was.
Yep, cool, but love that the most. Why is it a Battle of the Forms case?
Boilerplate going back.
It's true. If I had a bunch of boilerplate going back and forth as to whether or not I would teach a class on Saturday, would we be under Article 2 of the Uniform Commercial Code?
Probably not.
Why not? If you and I are going back and forth about whether or not I will actually show up on Saturday, and you're like, yes, I will incentivize you. Here's a promise. And I will like, yeah, but yes, and I need donuts. And you're like, yeah.
There's no conduct, like there's no contract yet.
No contract yet?
Because it's a service.
Because it's a service. What law do we use from services? The common law. What happens if I do a yes and under the common law? Rejection and counteroffer rule, right? You're right. You're all the way right. We are under the UCC. Why are we under the UCC? This is a good. What good is it?
These like air conditioning.
Yeah, these big frickin' freezers. Which means, and why are they goods as long as we're checking on everything? Because you can move them. With me so far? Cool. That's what we're doing. We're doing 2207. Then the question is, what happens?
So Gardner-Zemke is a general contractor for the government, the Department of Energy. They ordered from Dunham for these chillers, these air conditioners. They send each other boilerplate. A disagreement arises over the warranty. Some of these chillers are not good, and there's a disagreement of sending someone out and the cost. The DOE ends up just withholding part of their payment,
Right.
part of their ending payment. The lower courts incorrectly applied the common law year standard, and then following that, that was appealed, and the main issue was does the UCC allow for a contract to be formed if the parties provide conflicting terms?
If the parties provide conflicting terms. Okay.
And then
Yep.
just said yes if the terms conflict with each other. This is where the knockout comes into play. There's UCC provisions to go over very simple things like warranties for like a good like this.
Yeah. I think that's like really solid. And given what we just went over, that's most of the case. I know it's a long case and I know like it's a worrisome case, but we've actually just done it. I do need us to kind of bear down. What are the parties really fighting about with respect to the chillers?
Well, I think there was an issue, like they wanted someone to come out and fix it.
Yeah, the chillers broke down and needed to be repaired. And that's what they're fighting about is who pays for the repairs. Now, what's Gardner Zemke's argument that it should be Dunham Bush's problem to pay for the repairs?
Because in their boilerplate, they had something that would cover them during that time, and then Dunham Bush did not.
Exactly. So like you get to, right. I'm like, you notice I'm not calling for anybody opposing you on this. It's just like one side and the other. The lever's just moving back and forth so quickly now, right? Do you see it? That is, the buyer is saying, we had all warranties. The seller's like, we sold it as is, no warranties. So when it breaks down, did it get sold with a warranty or without a warranty? Now, let's not go any closer to the language of Dunham Bush because that will begin to screw us up. But let's just do our national framework that we just did. Where are we going in our flowchart? Is there a my way or the highway clause? There isn't. There isn't, but now we have to ask, because by the way, if you see the language in this case on my exam, I want you to make the argument it really could be a my way or the highway clause. Now in this case, the court says no. We'll talk very briefly about why. But what's the language? No, the language of the language in the statute, the language in the case where they're saying this was a my way or the highway clause because that would have prevented the formation of a contract.
I'm not sure where this wording was that there was.
Yeah, this is going to be on page 207, bottom of the page.
Oh, the big
Yep.
quote is
Yeah.
understood that our acceptance of this order is subject to terms and conditions enumerated on the reverse side thereof. It is being strictly understood that these terms and conditions become a part of this order and acknowledgement thereof. Basically saying like this is our rules.
Yeah, my way or the highway, right? My way or the highway. Do you see how that looks like a my way or the highway clause? On the bar exam, on my exam, I want you to think about whether that's a my way or the highway clause. I have to say, this is the kind of question the bar exam will not have the courage to put in front of you because there's not a clear answer, is there? Chris, win it either way. Win it, say that is clearly a my way or the highway clause, obviously.
I was going to do it the other way.
Yeah, do that. Cool. Let's do that too.
So this should have included, an extra sentence or comma saying that, disagreement to this is like required or like, word it, like, using this is an acceptance of this term. You understand?
Oh, I get it. By the way, what I love is that you're pulling out of all of this. Notice underneath all of this, just as a deep theme drifting along under the doctrine, we are moving further and further towards by doing something, you agree to the term of a contract, right? By submitting a bid, by. Anytime you say by, recognize somebody is playing some games at this point, right? So we're playing this by game, right? So the argument that it's clearly not is saying we didn't condition our acceptance on your assent. And that is the black letter law of Gardner-Zemke. The black letter law of Gardner-Zemke is, in order to act as a my way or the highway clause, it has to not only say it's my way or the highway. It requires the other party to say, yes, it is your way and the highway and I like it. It's adding that assent on top of it. It's not just saying it's my way or the highway. It's saying there is no contract unless you tell me you like it. Now they're doing that. Why would they do that? By the way, that's not how most courts read most of these clauses. Most of these clauses read, I just said, my agreement is conditional on this being part of the contract. It's a perfectly coherent sentence to say. My agreement is conditional on this term, on all the terms that I've listed being part of the contract. Perfectly coherent. But the court wants to make it like you have to use a supercharged version of a my way or the highway clause. You want to guess as to why?
Because that would point right to 207 where it says, even though it states terms additional, or unless acceptance is expressly made conditional on assent. Kind of like highlight that exact quote.
Yeah, so it's piling down on that quote, and that's what it's doing legally. Why would it do that as a matter of policy? Can you tell me why it takes, because that clause is pretty clearly a my way or the highway clause. Y'all with me? Pretty clearly a my way or the highway clause. Why is the court saying, sure, but even that my way or the highway clause isn't enough? And we can open it up to co-counsel if you want to take a crack. Yeah. They want people to read contracts. Actually, I think it's the opposite, by the way. Justice Roberts will tell you, nobody's reading these contracts. We don't know what to do. We're trying to come up with rules when nobody can read the contracts because they're moving too fast. Yeah. Because then every contract has one of those in it. Perfect. And they're like, well, then we've by contract removed this rule. Everybody see that? But the problem with that story is what happens after Gardner-Zemke? This is a great case on the doctrine. It's a great way to learn doctrine. It's the stupidest waste of time I can possibly imagine in terms of actual judicial impact. Because what happens after this case?
Every contract with hell or high water in it then?
Yeah, every contract not only says it's conditional, but
I'm going to leave if you don't accept it.
yeah, and you have to like it, right? If the problem the court was facing was everybody says this, and the court's like, yeah, but you need to say that, then everybody's going to say that, and you're right back where you were, right? Stupid waste of everybody's time, except it does teach us an enormous amount, like it helped the parties in that one case, and it gives us an enormous amount of learning about the case. Not much else to say about Gardner-Zemke. You've done an amazing job. There's not much more to say about Gardner-Zemke except that look at it, go, hey, we can't actually apply this statute as written. That would be insane. So we're going to go through all the different approaches that people have tried. And they go through a couple of approaches, and the one they settle on is the one that is least corresponding to the text, but makes the most sense, which is for 22072. Between merchants, additional immaterial terms may become part of the contract, whereas here, these are different terms, they knock each other out, and they get filled from the code. You with me? Cool. Any questions about Gardner-Zemke before we move on? Yeah.
So after cold terms, what does it mean, when they cancel out?
Yep.
And then the UCC imposes them, who ends up covering?
Yeah, and this becomes the big problem that causes a lot of the drive later on. So imagine you're a seller, and what you would like as a seller is to sell something as is, right? Because you don't want to make any warranties. So you say, I'm selling it to you as is. And then they respond back to you, they're like, no, we want all warranties. And then you perform. What happens? Here's what happens. First of all, what happens to my as is, all warranties? What happens to those two terms? Knocked out. There's a gap. What do we fill it with? Warranties. At which point the seller starts to go, y'all, I can't actually disclaim warranties. It's not possible, given practically where this ends up. How they fixed that, by fixed it, I mean they took away consumer rights across the country, is by denying one side of the ability to say anything at all. And we move to the one-shot rule, which we will be moving to when we say Stepsaver and Hill. All right, any further questions on Gateway, on Gardner-Zemke? The left-out rule and the knockout rule are different things. I have invented them. AI and Hornbooks will be very confused. Sometimes AI will call the knockout rule 22073. Sometimes they'll call it both. It's a lack of understanding. There's a very specific difference, and it's very testable. The left-out rule is a me-ism. I've made it up. But the left-out rule of 22073 says anything we don't agree on gets left out. That includes additional immaterial terms. Whereas, under 22072, we might have an offer and acceptance that do form a contract, and in that contract, we might have a term that is only in one contract, as long as it is between merchants and is an additional immaterial term. So that's the difference. The knockout rule, I have to say potato to knock out your potato. In 22073, if you say potato, and I'm just like, yeah, I'm not talking about legumes today. Well, it doesn't come in because it's not in both of our contracts. All right. Cool. Let's move then into Stepsaver and the next economy. We're going to start at the beginning of the next economy. And I need you to understand why the courts are making the moves that they are. Let's see, Mike, would you mind setting up Stepsaver for us?
They were marketing they sue both for the feedback. But the appeal, it's TSL.
It's about the software,
Yeah.
right? We are moving into the intellectual property economy. We have now left the factory economy behind.
So, after a sort of initial period of testing and negotiation, they began to buy the software from TSL, and how they would do that is they would usually call on the phone and order blocks of 20 programs at a time. And then TSL would accept the order on the phone and promise to ship the goods promptly. After the order, StepSaver would send a purchase order detailing the items being purchased, their price, and shipping payment terms. TSL would ship the order promptly along with an invoice. The invoice would contain terms essentially identical to those on StepSaver's purchase order. No reference is made during the phone calls to any additional terms.
Right. So no reference, no, and that's going to turn out to be important. No reference was made. What's the court then decide? Was there a contract? Yeah. What were its terms? Did it include these additional terms that got shipped with the software? Or was the contract, great, watch the lever. Watch the lever. When was the contract formed? On the phone. What were its terms? The terms, what were its terms? When it was on the phone? The conversation. What do we need under UCC 2201 to form a contract for the sale of goods? What would you need? What would you imagine they said when they called up on the phone?
I'd like to buy
20 of these things, right? And the response is, I'm happy to sell those to you for money dollars, right? And then maybe we have an additional immaterial term where I say I will ship you the CDs in a stack of 20, right? Can you see that as of that point there is a contract? There is a contract at that point, right? Can you see that if the CDs don't show up, you could sue for breach of contract? Right? Cool. Then what does that mean for the terms that follow along later if we follow StepSaver? Yeah, they're proposals for addition. By the way, what law are we in here? And this is a totally unfair question. We're under the UCC. It's true, we are. Why would it be a question as to whether or not we're under the UCC?
At least at this time, software wasn't settled, whether it was a service or
Right, software's not settled. And to this day, by the way, it's the can you pick it up rule. Like if you buy it in Best Buy, it's a good. If you download it direct, good luck. I don't know. It's intellectual property. As we'll see, that gets hand-waved in another case. A lot of courts still say if you download it to Steam, it's still a good. Why? Because it's like something you would have bought in a Best Buy if you could have. But what I need you to see is they're reaching at this point for law, right? They're trying to get extra stuff in there, but they are applying the UCC. Okay, and then under the UCC, right, under the common law, we know how this would work. The contract is formed. Anything that they try to add later on is like a yes and after you've already accepted. It's like Ardenti versus Haran, remember? How we say yes and then check something? We say yes, and then we send a separate request saying, hey, by the way, can we change this? And if the other party doesn't respond to that, then what happens? Yeah, yes, there's a contract. The terms are the ones that we said on the phone. There are no additional terms. That was our deal. I need you to see it clearly because that is almost nowhere the law. And I need you to be like, what the actual hell? Is there a difference between what we just studied and this? No, there's not. But I need you to understand this is what it would have looked like if a court would have applied the law. If the court would have applied UCC, what would happen is the parties concluded a contract. The additional terms were additional material terms that in this case were in fact between merchants. So the immaterial terms should have come in. But any different or material additions, nah, right? But we all know from clicking I accept, that's not how the world ended up. But I need you to just think about StepSaver, think about where the contract was formed, what the arguments were, and why the court says, no, you don't get to conclude a deal and then tack a bunch of extra terms that the other parties never agreed on afterwards. What? In what world? In what world? All right. Everybody doing that? Everybody clear on that before we get to Hill? All right. Let's move on to Hill. Well done. So there's one detail case that we'll talk about. It's on the bottom of 227. I'll just mention it. At this, much earlier, the Supreme Court had started saying things like, yeah, you don't actually have to see and read and agree to everything. And they started doing what were called contracts of adhesion, where if you went on a Carnival cruise, your ticket would have a bunch of language on the back. And that's what Carnival Cruise stands for, that you can be bound by these contracts of adhesion, that they actually work. And they're all by arguments, right? By doing what do you trigger the legal language on your ticket for Carnival Cruise? By stepping onto the boat, right? By redeeming, by going into the movie theater, by, these are all by cases. What they're doing is they're moving some ordinary action that some human would do, and they're making it the means that triggers acceptance of a contract that the party involved has never read. So that's what sets the stage for Hill. But I just need you to see that in the background. Also, by the way, when it did set the stage for Hill, it was a pretty sketchy proposition. As we will see later on in the course, a lot of these contracts of adhesion get knocked out by being so unfair no sane human would agree to them and no honest human would offer them. That's literally the standard for unconscionability. And so, but that state of affairs then is where we are when we hit one of the worst cases in American jurisprudence, Hill versus Gateway. Joanna, would you mind setting it up for me, please?
So the Hills based on an ad for a computer that Gateway was advertising.
Yep.
And they made this purchase, but when the computer was delivered to them, they had a bunch of complications with it. So there was like terms, but it was in the box, and one of it was called a fusion clause. And part of that, and well, the Hills say that the arbitration clause did not stand out to them, and they just didn't read it. And so they did have like a policy where if they had a problem, they could return it, but it was within 30 days, and they did not return it, but they had problems like throughout.
Okay, got it. What's the black letter ruling of the court before we then get into what the actual hell Judge Easterbrook was doing?
So I don't fully understand it, but
Yeah, well, neither did the judge.
I think he thinks that 2207 does not apply here.
Okay, let's start with that. So he knows he's got problems, so he starts with something that is just completely false. Why does he say that 2207 simply doesn't apply? Because there's two reasons he could say that. One, we don't apply the UCC, or two, 2207 is not the rule of the UCC that we apply.
Well, he said, in his opinion for the pro CD, he said that when there's only one form, 2207 is irrelevant.
Yeah. Is that what 2207.1 says? No. Give me some definite and seasonable expressions of acceptance that you might make if I send you an offer, right? So mine is the offer. There's our language. Mine is the offer. I offer it to you. Give me something that you might do such that there's only ever one form. You could just accept it. I don't know. You could pay for it by conduct. You could offer any definite and seasonable expression of acceptance. It doesn't say you have to have two forms. This is the worst kind of judging. Where the court does is it doesn't even take the name of the statute, 2207. It takes what lawyers named it, the Battle of the Forms, because that helps describe it, and then says that what lawyers name it at cocktail parties actually is what it is over the language of the statute itself. So the first thing is he's just like, this doesn't apply. He's just flat wrong. He's just flat wrong, which is a problem because I'm going to criticize Gateway so roundly. I need you to understand it is absolutely the law on which the entire internet is based, In fact, it is law so powerful that the cases end here. There are no more cases about technology law and consumer protection. Why are there no more cases after this case, Joanna? Well, what happens if the Hills lose here?
Well, they lost, according to him, they're held, they're bound to the contract whether they read or don't read it.
Yep.
So it's like, okay, well, everyone else, if you don't read it, then you're.
Right, and when they're bound, so he makes the contract inescapable, right? And what happens if you are bound by it?
Well, if there's an arbitration clause in it, then obviously you can't have a case because you have to.
You are forced into arbitration, and what's the nasty thing about an arbitral ruling, Leland?
The person in charge of arbitration is representing the one side, so you're kind of just screwed if you.
Well, I mean, there's a great 2015 New York Times expose on this problem, but basically, look, if you're a company, you get sued all the time, right? And if you're a human, you don't sue often, so you can imagine who the arbitrators know pay the bills, right? That's one huge problem with it. But two, what's the other problem with an arbitration ruling?
It doesn't create case law.
It doesn't create precedent. It doesn't create case law. If law is a coral reef, they bleached it. They killed the living edge of it so that it can't grow anymore because, and after this, there's like one case by Apple that pops up because they took their arbitration agreement out for a split second, got the living bejesus suit out of them, and then we're like, no, we're gonna go back, right? It's like that meme of the little squishy guy inside the iron box. They opened it up, they're like, never again. We're armoring back up with this arbitration agreement. Okay. So I need you to understand why this was such a huge damn deal. It's such a huge damn deal that, in fact, we can't get more opinions saying Easterbrook was completely wrong. We can't get them because all of those cases are forced into arbitration. All right. Let's then try to dig a little deeper into the black letter law here. First, I want to just start at the beginning. Joanna, if you go through the series of events, and then say, as an attorney, could you please just re-narrate quickly what happened in this case? And then tell me when you would be comfortable at the first point saying, yeah, there's a contract here. In fact, if the parties don't perform, one party could sue. Tell me when there's a contract.
Wait, so do you want me to go to the facts again or when I?
You could start applying what you think and you know from this class to these facts. Don't follow Easterbrook's analysis. Just say, at what point in these facts will you take money as a lawyer and sleep well that night to say, yeah, I saw offer acceptance and consideration right there, and in fact, it's got a lot of law to support it.
Well, I would say offer would be the.
Like, there's the ad. What do we make with what do we say about the ad?
That's an invitation.
Yeah, that's just an invitation to treat, right? We saw that in Ford Motor. Probably, could we make that into an offer? We could. What case would we apply to say that? We will lose. What case would we apply to say, yeah, it could be an offer? The Pepsi, that's one that says later on, no, we won't treat it as an offer because even though it looked like an offer and acceptance, it's still a Harrier jet. We're not letting you get a Harrier jet. But the Ford, yeah. Ford Motor Company, but Ford Motor Company references one that's going to be in your. There it is. It's called Lefkowitz. Lefkowitz, or what's called the Lapin stole, L-A-P-I-N, the Lapin stole. The reason I raise it is it'll be in horn books or commercial outlines if you go look. We might try to make that the offer, but you and I know better by this point. We're going to think that one probably is not going to work. It's been broadcast out to everybody. It doesn't create the power to accept in the acceptor. So we're going to have to wait. We pushed that lever as far as we could. We're like, we can't really do it. Like Lefkowitz, fine, but it's not going to be my first argument. Let's back it up. When's the next place we might say there was that click?
The offer.
Yeah.
Well, I would say when they purchased.
Yeah, so how did they do that?
Well, they purchased over the phone.
Yeah, so they got on the phone. I have to say, folks, one of the most maddening thing about this case is that it is all about the fact that Easterbrook does not understand the internet and thinks that the internet is like phones. And I'll prove it to you later on. This is a case about phone law that destroyed the ability for Americans to go to court. A freaking phone law case. It'll be important that this was a matter of the phone. So they get on the phone, right? Now, at what point is the click? Hello, I would like to buy one Gateway computer, please.
Providing their hardware information and purchasing it.
Yeah, and then what was the response of the seller?
Like, okay, yeah, well,
Sure, it will be money dollars. Here's my credit card.
and
We'll do that. All right, look, under any reading of anything, is there a contract at this point? Holy shit, of course there is. If the computer doesn't show up, can the Hills sue? Yeah, absolutely. What are you talking about? All right, cool. Now, let's just keep going though, for the sake of argument. Let's say that that's where we could have our click. But now we're opposing counsel, right? Where does Easterbrook put this click? Because what's the problem with the way Easterbrook looks at this?
there's a lot of problems.
Yeah, there's a bunch of them, right? So the one is he says Article 2 doesn't apply. He's just flat wrong about that.
Well, the one form thing is just like.
He's just flat wrong too, right? But where's his, look, what's his problem with saying that there's a click at the moment you get off the phone, Jake?
Easterbrook says that, citing his own opinion per CD, that the contract is formed until the customer has had a chance to inspect both the item and its terms.
Okay, which is insane. Justin, you were going to say?
Yes, exactly what I was gonna say, until the customer has the opportunity to read over the agreement.
Okay, so that's what he says. That's what he says. He has the opportunity to, it doesn't occur until the contract shows up. Even you know way better than Judge Easterbrook. You all do. Why is that obviously wrong? That is obviously wrong, that the contract is not formed until the person gets it and has an opportunity to see all the terms and then keeps the computer past the 30 days. That's what Easterbrook says, and that cannot possibly be right. Yeah? You've already performed the contract. I mean, let's try it. Remember what I just said? If the computer never ships, can the buyer sue? Sue on what, Judge? Breach of? Yeah, cool. What contract, Judge? Which one? The one we made over the flipping phone, Judge. So he's already really missed the boat. He's made two horrible mistakes that later courts have to help fix, or none of this works. And they did. They kind of fixed it, and it now became the law of the land. But I need you to see how wrong it is on almost every front. So we know that he can't be serious. And when you get into upper level classes, it turns out he really can't be serious about this. Because if you push the moment of contractual formation until after the person gets it, you will learn next year, not now, but next year in Article 2 sales, you will learn that there are specific things that the buyer gets to do, powers, remedies they get if it shows up. The biggest remedy, if it shows up, the computer's cracked, you get to call them up and say, come pick it up, I don't accept this. And then they have to do it because otherwise it's a breach of contract. Breach of what contract, Judge? Right? Judge Easterbrook says with a straight face, and he's flat wrong, that there is no contract until the person has had a chance to review the terms. Now, if you had to fix his insanity, how would you fix his insanity? Because there's got to be a contract with that. You hang up that phone, that click you just heard, as you hung up the phone, that is the click of a contract. It clearly is. So how do you fix him? There is no contract without acceptance, but even we just said that there's offer, acceptance, and consideration. When was there offer, acceptance, and consideration in this case?
When they purchased the computer and it arrived.
Click, right? As soon as they hang that up, they purchase it on the phone, click. That click is the click. There was the contract, yep.
Instead, you'd say that there was the initial contract and then you just renegotiated it when you got the new terms, and then they accepted that when they didn't return.
Well, so if we, great, I love this procession. So let's try to say that. Let's say we did have an initial contract, but the additional terms were an attempt to renegotiate it. Why would we say something like that? That additional terms are proposals for addition to the contract. Why might someone say that with a straight face? Oh, I don't know, because it's the law or something. Crazy argument, right? Nuts. to say that the law says in black and white, and it is not at all unclear, that these additional terms are proposals for modification of the contract that we made when we get off the phone. And are these additional terms, which include lack of warranty provisions and an arbitration clause, do they come in and become part of our contract? They do not, Jake. Why? On about 4 different reasons. They do not because...
They don't because they're not expressly accepted by the other side.
Do they have to be expressly accepted by the other side?
Well, they differ from what the original contract was.
They differ from the original contract was. Does that prevent the formation of a contract? They materially alter the contract. That would be argument 1, right? Although the response there by courts has been to say arbitration provisions arbitrarily do not constitute material alterations of the contract. I think that's insane, but that's the law. So that's how they deal with that one. Give me another grounds on which this obviously does not, these additional terms are just proposals that unless accepted, do not become part of the contract. Yeah, because the Hills aren't merchants. This is the core of their whole case. The core of their whole case is say, wait, what? There's only one way that I'm aware of that you get to add a term that's not in my deal and bind me to it. There's only one path, y'all. We have an offer and an acceptance that are different to each other. That's fine. But anything you send later on is a proposal to renegotiate, is a proposal for modification of that contract, and it doesn't come in except under the framework that we've set out for Article 2. That was the Hill's entire point. That's what Judge Easterbrook was hiding out from. That's why he said, Article 2 doesn't apply, Article 2207 doesn't apply, there's only one form. You don't need only one form. You just need an offer and an acceptance that are different from each other or a confirmation that has different terms from the offer and acceptance. That's all you need. Okay, I hope everybody sees it, because now we got to fix Easterbrook's clear nonsense. Let's maybe dig down. Why did he want to do it? Why did he do it? Like, forget the law. Why did he do it? We know what he's like. We know what he's like, yeah?
Kind of said it would be better if customers just skip the interaction steps and the acceptance would be simple for them.
Yeah, it just makes acceptance really simple, and
I was gonna say, he said it was ridiculous to the idea that somebody, if you called and purchased something, they'd have to sit through 45 minutes if here's a 4-page contract.
right. So that is the specific technological reason that he uses this case. He says it's impossible to read contracts down the phone. What is profoundly ironic about that?
No one really buys stuff over the phone.
Nobody buys stuff over the phone. In fact, is it incredibly onerous using a computing system to provide every term of the contract at the point of sale? Is that an impossible thing to do? Easterbrook is so behind, he screws up the entire internet because he can't deal with being read terms over the phone. It's the dumbest thing I can possibly imagine. Now it gets worse. Yep.
Yeah, but this is a 1997 case, though.
I lived through it. I was there.
It was definitely like far less like.
Sure, I get it. No, I get it. It's just that, by the way, let's try this. What is the technology of 2207? If the telephone is the technology of Hill versus Gateway, what is the relevant technology of 2207? Boilerplate, contracts being sent by each other, by one person and the other.
Like the mail?
The mail? It's the fax machine. It's the fax machine, right? People are faxing each other these order and these purchase confirmations back and forth. And then we made a whole, this is the law of the fax machine. I swear on a stack of whatever you hold holy. That is exactly what that is. And this crap is the law of the telephone. I just want to point out the core reason that Easterbrook did this damage to the law, which is he didn't want people to have to read the terms down the line of a telephone, has nothing to do with the law that he made. And in fact, it was already outdated by the time he made it. It was just a disaster across the board. All right. So we know he's wrong, but let's try to reconstruct what he did, because this is the law of the land. The problem here is that it flatly contradicts the law. This breaks down to a point that we were making before class, which is there is no distinction between the two scenarios. There is none as a matter of law. If you see a computer offering a human a contract, you use Hill. If you see a business doing business with another business, you use UCC Article 2. Are both of them claiming that they're under UCC Article 2? Yeah. Should it make a difference? As a matter of law, no. Judge Easterbrook is flat wrong on both counts. He says there needs to be 2 forms for there to be a battle of the forms. He's flat wrong. And he says the contract wasn't formed until after the parties get it and keep it. He's flat and provably wrong. We have to fix him because otherwise this can't be the law of the internet, even if it's terrible. It is terrible, but at least we have to fix it or we just can't take ourselves seriously as lawyers. So we're not going to be able to say, we had a deal, but these are proposals to modify that deal. These are proposals to change the deal because we know what happens if that's the case. Nope, if the Hills say no, they don't become part, the arbitration clause, which got added, doesn't become part of the deal because the Hills didn't say yes. Like perfectly straightforward. So is there any way we can fix what Easterbrook said where he's like, he's wrong, we can still preserve the sense the contract must have happened when they got off the phone. Otherwise, nothing works. But also then validate this, these extra terms that get sent along. Is there any framework, any way you can think about it? And he kind of mentions it. Yeah.
There was when they sent the terms, it was a proposal to negotiate, and then by not returning,
He accepted by that, and that is his theory of the case, but can you see the problem with that theory of the case? If that theory of the case is true, could the Hills sue if the computer never showed up? If that theory of the case is true. No, they couldn't. Why couldn't they sue? Because there's no contract until they get the thing and keep it for that period of time, right? If we take Easterbrook seriously, we can't. So we got to do something else. And he talks about it as if it were a thing. And that's what he does. He creates a new idea out of whole cloth. He calls it rolling contracts or money now, terms later contracts. What he's saying is, we are perfectly, and he doesn't say it. He, in fact, screws it up because he says exactly what you've raised, and then our analysis is like, yeah, but that doesn't work. But the courts that come along later that fix it, and we'll ask why they fix it in a minute, but the courts that come along later and fix it say, no, it's clear. When you get off the phone, there was a contract, right? It's just that both parties knew at the time of the making of the contract that terms and conditions would follow. And that because you haven't had a chance to look at them, if you don't like them, send it back, and we'll get you back out of the contract. There is a contract. There is a contract. It's just you've got the ability to say no if you don't like the terms. Do you see that? By the way, just because I have actually taught you well, as opposed to whoever the hell taught Easterbrook, what's wrong with that picture? That is the black letter law. But what is wrong with that picture, Bailey?
How are you gonna get your money back if there's no contract yet? Like you can't sue for anything.
Well, right, or how would you get your money back? Well, because that term would be set, right? Like even, let's try this. Even Judge Easterbrook would say, I would like a computer, please. It will be $1,000. Okay, ship it. And then the computer comes and they're like, that'll be $1,500, please, which is a changed term. And if we took Easterbrook seriously, that would be fine. But even he understands, no, we had a deal. The deal had a price term. You don't get to change that later on, right? So even he, we know, doesn't fall for that. Yeah.
So the problem is, in situations like this, consumers don't have a way to renegotiate terms they object to. They just can't buy computers.
So they can't buy computers. They can't renegotiate the terms. Here's the problem. If you leave it all the way over here, there's all kinds of contractual stuff that goes on here that we know happens and that can't work. We have to use this framework of saying, nope, it was formed here, but then we mailed the terms that you knew were going to be coming, and if you didn't like it, get out of it. The problem is, and I'm going to damage your brain, what do we call it when we say, I will be bound by a contract if I feel like it? Illusory, right? Like Easterbrook just walks right into it. Do you see that? Let's try it. Could, practically speaking, could Gateway sue the consumer under Easterbrook's theory if the consumer gets the computer and it turns out it's that gunmetal blue color, not the titanium I actually wanted, even though I didn't tell them at the time that I wanted titanium and not the gunmetal blue color. And so I just don't like it, and so I send it back in full breach of contract. Can they sue me if Easterbrook is right? No, they cannot. Why? Yeah, it's illusory because if I don't want to keep the computer, what do I say? No, I do not agree to these additional terms. I have this complete right. Oh, by the way, just like to make it, to really drive home the point, because that is what Easterbrook says. Easterbrook says, when we got off the phone, there are two things that were true. We had a contract. That contract had a term that no one mentioned on the phone, and that term is that more terms were coming, right? And then when you get the thing, you have, here's another term that gets added to this contract, and that other term, which is not in the contract, but Easterbrook adds to the contract, is if you keep it for a period of time longer than necessary to review the terms, then you have agreed to the terms of the contract. For somebody who calls himself a strict textualist, that man is adding a whole lot of crap to contracts that he just has pulled out from underneath his robes. He is making stuff up at this point. He's implied two terms that frankly weren't there. The one term saying, we have a deal, but there are more terms coming. And then the other term saying, oh yeah, and if you don't like him, you get out for free. Why does he do that? Why does he, even in his most ridiculous framework, why does he have to say, I am going to make up a term out of whole cloth? Judge Easterbrook is a textualist, right? He hates just adding words to stuff that judges make up, but that's exactly what he's doing. Why does he have to do it? Why does he have to say, if you don't like these terms that follow along, you get this free ability to walk from the contract? Why does he have to do that? Yeah. He wants more trades to go through, and that's maybe his best argument. We'll get to why he's right on the industry but wrong on the law here in a second, after we've thoroughly trashed him. But why does he have to add that term? Let's say he didn't add that term, saying, if you don't like it, you can get out no matter what. That's the term that he just found, made up, and put in every contract. What happens if he doesn't?
Then there's no consumer protection.
Then there's no consumer protection. What happens? Go ahead.
Reliance?
Well, we'll have to start getting into reliance absolutely as a solution for this, Jake, yeah? The consumer will absolutely be bound by the new terms. And what's the problem with these new terms that not even Easterbrook can recover from? Not even Easterbrook can solve the problem of these new terms because they weren't part of the contract and because the consumer's never seen them. Look, the Supreme Court will bind you to contracts you have had the opportunity to read but have not read. But even the Supreme Court won't bind you to a contract you've never seen. Do you see why he has to do that? At this point, it's just mental gymnastics. He gets a gold medal, right? He's doing a triple backflip to save the insane framework that he's generated. Why did he do it? Why was he so hell-bent on creating rolling contracts, money now, terms later agreements? They've become incredibly popular. They do run the internet. We have to see why he did it. He certainly didn't do it because it was the law. He's just wrong.
His mindset was based on that it would be more efficient economically?
Yeah, he thinks that it'll be more efficient economically. What's the economic argument?
Well, if customers, if they put in enough time and when a customer buys something, they put in no time, no energy, and everything.
Yeah.
That just goes away.
Yeah, what do we call the energy and the time that a customer spends going over contract terms? By the way, how many of you have read these contract terms in like these massive I agree agreements? Yeah, I'm seeing a few people have read them. Most of you haven't. And if you had, did you negotiate a change in them? You see, from his perspective, what a massive waste of time. What do we call a waste of time if we're talking econ? Because this is the University of Chicago school that traumatized me. We call that a transaction cost that leads to deadweight loss. He's worried about deals not going through because of imposing extra obligations. Let's try this. This would be perfectly consistent with the law, but no one's ever going to do it. To say, you are not bound by a contract that you've not completely read. You think any court's ever going to say that? Absolutely not. I had a client one time who was installing apps, right? He had an app in the App Store. He said he lost about 30% of people interested in his app between the time they showed an interest in his app by downloading it and the time that they actually got it working. A 30% loss of customers every 30 seconds it took them to get it up and running. Just like if it wasn't running by the moment they hit yes, just nope, gone, like I'm off, I'm not using your app. Easterbrook's not wrong about the devastating impact that transaction costs can have. Why is that true of apps? Why do apps, you either get it working in 30 seconds, the person's like, absolutely not. Why is that part of this framework?
Well, just because like we were using an app, expected to download.
Yeah, they,
Supposed to happen instantaneously with the software you're using.
Right. That is, they're expecting commerce to speed up. More transactions, more immediate responsivity. Can you see that Judge Easterbrook is flat wrong on the law? I get it, he's flat wrong on the law. But can you see what he's doing? He's speeding up computer transactions by essentially forcing humans to accept the terms that they're given, but he is at least speeding up transactions. Okay. Yeah,
But he also misunderstands like the change in the economy in the late 90s because he's really obsessed with big box stores and phones.
Yep.
And as you may know, if you use the internet to purchase something, it's closer to shopping in a store than it is to shopping on a phone. Because you can see the item, you can analyze it, and you can click to open the terms. It's not anticipating efficiency, but he's just imagining somehow the proliferation of the call center.
He's exactly, his transaction cost, so transaction cost theory might be right, but is it a high transaction cost to present all of the terms of the contract to the consumer before they buy? His core proposition remains now wrong because he's one generation behind on the technology. Exactly. Yep. Okay, any questions about Gateway? It's in a tremendously irritating case. Go ahead.
So are illusory contracts the same thing as rolling contracts?
No, what we just did was we talked through the arguments of Judge Easterbrook, and then we talked about why he was wrong, but then what courts have done to fix it. But even if what courts had done to fix it were true, it would mean that the contract was illusory because he just gave every consumer a free option out. Do you see it? To save his contract from the rank bullshit, the threat of enforcing contract terms against someone who'd never had the chance to see them. So in order to fix that problem, he creates another problem. And that's where the illusoriness comes in. Yeah.
What's the difference between this rolling contract and just renegotiating an initial contract?
Here is the key difference between a rolling contract and a renegotiation. If our model is renegotiation, we have a deal. This is Ardente versus Huron. We have a deal. We are now renegotiating the deal. So I would like to buy the house. Oh, by the way, could you please confirm whether or not the bell comes with the house? That's Ardente versus Huron. What does that turn into? The danger is it'll be a counteroffer, right? It'll come back and forth and back and forth. In the UCC, we're not under the common law anymore because that's Ardente. In the UCC, it does something similar. It says, well, if we have a deal and you are renegotiating it, the additional terms are to be construed as proposals for addition to the contract. If they're not agreed to, they don't come in. But Judge Easterbrook removes the battle of the forms and calls this, he doesn't call it the only shot rule, but we should call it the only shot rule, by saying when there's only one form, then there's only one set of terms to the contract. Now he's wrong about that. We actually have two sets of terms, the terms you established over the phone and the terms that came later with the writing, right? But he says that there's only one set of terms, which means that it's not a renegotiation, it's just simply, you agreed to a contract that you haven't seen all the terms for, and then he creates this law saying, once you've seen them, you get a free option to back out. And he just blunders through contract law, destroying doctrine left and right. Because what he notices is, I don't want to make people read this stuff over the phone or read it before they sign, because if I do that, I will kill off the industrial and the internet economy. He's right about that problem, but the solution is to use the internet to give people all of the terms before they buy. That's the solution, not to destroy everything that we've ever known, which is what he actually does. Yeah.
Has there been a retrospective statement by Easterbrook on this decision?
He gets, no, but then apparently there was like one moment when he was on stage and somebody asked him about it and he got super mad. I think he knows that, he knows, right? Like he knows that the decision has come under colossal amounts of criticism. On the other hand, it is the law of the country. To be very, very clear, this is probably the most influential decision we will look at this year. It completely changed everything for and set the tenor for the data economy that we live in. This is the basis for it. Yeah.
You said it was fixed a little bit after the fact.
Yeah, it was fixed by saying, because look, if you said what he says in the decision, which is the contract's not actually formed until the person gets it, can read it, and then keeps the thing for a while. First of all, that's really strange because it's only formed once you've passed an arbitrary amount of time that Judge Easterbrook just suddenly randomly found in the back of his mind, right? Like the whole thing's weird. but that's when he intimates, he suggests that's when the contract is formed. The response is to say, no, this is not a renegotiation. This is, there's one deal, we just established a few of its terms on the phone, but you understood more terms were going to be coming. And you also understood that if you didn't like it, you would have a free option to send it back. Now, none of those things were in their deal, but Judge Easterbrook implies all of those things because he wants to protect the speed of internet commerce. We have 1 minute left. Question? Yeah, go for it.
So like, you know when you like buy a phone at the store, right?
Yep.
And you're presented with an I accept term when you buy the phone, but then later on you download it and you have to accept again.
Yep.
The system or something is just the use
Yep.
of the phone.
We're going to get into how this overlaps with Lakeland. Remember our one more day rule of Lakeland becomes one more breath after Gateway versus Hill, right? All these things start to come together and we see how they've mutated. And interestingly, by the way, the doctrine that we started, contract is the law of bargain for exchange. Are you bargaining with Amazon? This is what professors Shoshana Zuboff and others call anti-contracts. What you've just watched is contract law flip entirely into its opposite through the development online. Okay? We'll stop there. We'll pick it up on Saturday. One time I will look for Monday slots so that we do not take away another Saturday of yours.